Hello, everybody. I'm a California criminal defense attorney. Nothing I'm going to say here is legal advice. It's just my own 2 cents. We're going to talk about looting because it's happened already in certain places, is happening. It's probably going to continue to happen on a mass scale in the coming weeks and months as the economic hardship surrounding the coronavirus pandemic and shutdown gets worse and people get more desperate. Personal protective equipment, hand sanitizer, toilet paper, and indispensable food items like milk are increasingly difficult to come by. So that means the temptation to rob or burglarize to get these things has never been greater. What I'm going to do here is talk about the consequences of giving into that temptation, and that includes being prosecuted for murder. All right. There are 2 rules in California criminal law that can get you charged with murder in a looting situation, even if you didn't intend to kill anybody in the process of robbing or burglarizing. The first one is the infamous felony murder rule. Robbery and burglary are felonies considered to be implicitly dangerous to human life. And because of that, if the target of the crime or even an innocent bystander were to die while you're looting, then you're probably going to get hit up with a murder charge, even if you didn't intend to kill anybody. All you wanted was that last toilet paper roll sitting on the shelf, right? Suppose, for example, you and your friend hold up a liquor store, convenience store, or grocery store, and you get into a struggle with the owner of the store. And because of that, the store owner dies. In this situation, you and your cohort being prosecuted for robbery would be the least of your worries because you're probably going to get charged with murder. Even if neither you nor your cohort deliberately set out to kill the store owner, because the intention is already implied, the intent to kill is already implied by virtue of you carrying out an inherently dangerous crime, that is enough for the intention element of a murder charge. Another rule that could result in a murder charge is the provocative act murder doctrine. Here's what it says. If you're carrying out a burglary or a robbery, you can be charged with murder even if your cohort, the guy you're stealing with rather than the target of the crime, is the one who dies. This would happen if you do something beyond what's necessary to carry out the robbery, like brandish your gun at the target of the crime while you're threatening his life. The act of brandishing the weapon alone is considered a provocative act. In the store owner example, say you and your buddy broke into the convenience store waving your gun. The store owner shoots in your direction, misses, and your partner in crime gets the bullet and dies. Guess what? You are responsible for that killing, even if it's a store owner who pulled the trigger. As you can probably guess, it's called the provocative act murder doctrine because the law interprets your actions to have provoked the target of the crime into defending himself using lethal force. Crimes of this magnitude generally carry life in prison without the possibility of parole. If you or a loved one succumbed to the temptation of robbing or burglarizing, call us today. You can go to our website, lawyerinmyarea.com. All our contact information is on there, or go to the top of our Instagram page if you're viewing it on Instagram. We can identify all the appropriate defenses and get to work in getting these very serious charges dropped or reduced. Stay safe.